I'm here again with Gary Fraley, founder and owner of the Fraley and Fraley Law Firm. Today I have a couple of common misconceptions that people bring into the office, and I want to share them for this larger audience so that we can iron them out and figure out what's true, what's a misconception, and where the actual answers are here. So getting right into the first one here. Many people are coming in with the belief that you lose things. You lose everything you own when you file for bankruptcy, that a trustee shows up at your house and takes account of all your furniture and belongings. What's the real story on this? So what things are actually at risk? What things are protected in a bankruptcy?
Well, in California, we have two systems of what's called exemptions. These are the things you get to keep. You get to choose one or the other. One is great if you have a lot of equity in a home, which is seldom nowadays. The other has a lot of flexibility. The people that come in my office, less than probably 1 or 2% lose anything in a bankruptcy. And usually those that do lose something, it's because we had to file a stop of foreclosure and we can't protect all the assets. People don't lose assets. They don't lose their cars. They don't lose their home. They don't lose their furniture. They don't lose their retirements. All of this is protected along with much more jewelry, and the list goes on and on. Life insurance, cash surrender value, things like that. All that has protection. So it's not a we're going to lose something.
What's the best way for someone to make sure that they don't lose anything when they file?
Immediately see the attorney, because if you have something that is not protected, we often can convert it into something that is protected. And that's really the key here. Planning is everything. Timing is everything. And the more time we have to fix the problem, the better the result's going to be. That's essentially pre-bankruptcy planning is a forte for us. We're not here to fill out papers. We're here to get the right result for the client.
One other thing that we're hearing, and many people are being told this by their banks, is that if they're applying for a loan modification, they can't do a bankruptcy, or else that will screw up the modification process and ensure that they lose the house. What's the truth on that? How does a bankruptcy affect a loan modification?
Well, as of June 1, 2010, the filing of a bankruptcy is not a basis for failing to cooperate with a client in doing a loan modification. So I have lots of clients that have filed straight bankruptcies, even Chapter 13 reorganizations, and been granted a loan modification. In fact, under the new laws, there's a lot of things that normally they would be asking for, and you just give them a copy of your bankruptcy documents, your bank statements for 6 months, and your tax returns, and that's all that they need to do it. And if done right, and I would explain how to do it right in here, you can put it in a point where they don't lose the first 6 sets of documents that you send, which is a common complaint that I hear.
I've never heard of that before. Bank of America losing documents? That simply doesn't happen. See, I've got a third one here. The credit impact of bankruptcy. The conception out there is that if you file bankruptcy, your credit is trashed for 10 years, and that you essentially have to choose between getting rid of your debts or having this credit nightmare where you can't get credit for a decade. What's the real story there?
The real story there is that that's an old wives' tale. It is not something that's reality. I have people get credit within weeks or months after a filing of a bankruptcy. Keep in mind that if you are in trouble financially and you can't get credit now because you already have a pile of debt that you can't pay, you're not going to fix that probably for the next 20 years if you made payments on those debts, because they eat up the interest, it takes your mortgage payment, they take your credit card payment, and it all goes poof, and you still owe the debt. And especially if you're behind, you got late charges going up, over limit charges. The second you're behind, they jump the interest rate, whatever. You're not going to get out of that unless you hit the lotto, and I don't recommend trying, or you get rid of the debt using a bankruptcy.
And they say the lottery is a tax on people who can't do math.
Exactly. Stay away from that. I've got a lot of clients that tried and went up, and maybe they go to Thunder Valley in hopes of getting the big spin. Unfortunately, somebody pays for those lights up there, and you don't want to be the person that's paying for those lights.
So where is that figure of 10 years coming from, and what's a more realistic number for how many years your credit's going to be in the tank?
The 10 years comes from the fact that it's on a person's credit for 10 years. That has nothing to do with whether or not the client's going to get credit or rebuild credit. The average person is completely rebuilt on their credit in 3 to 5 years. And despite it being on the credit history. See, the credit industry wants you to think you're not going to get credit because they don't want you to file a bankruptcy. If they are such that you know the truth, then you know, forget them. Don't believe them. Their only goal is to get your money in their pocket. The goal in here is to get control of your life back.
Well, I'm sure this is only the first of a series we're going to do on these as more misconceptions come to light. And I want to thank you for taking the time to address them. I'm sure you're saving people from a lot of confusion today. So thank you very much, and we'll talk to you again next time.
Thank you.